Ian Forrester, welcome to Digital Markets Research Hub. Thank you very much for finding time for this conversation. It's a great opportunity. I'm sincerely honored and grateful for this. I wanted to start this conversation with inviting you to provide your outline and diagnosis of the situation of competition law today. Are we witnessing some unknown challenges and changes, or it's pretty much the same in different arrangement?
Well, first of all, let me say that, as you can see, this is being recorded outdoors, and if you hear in the background strange noises, it could be traffic passing, or it could be the wild boar who live in the forest having arguments between themselves. But the sun is sort of shining, and I'm sitting outside in my lovely old building in the Belgian Ardennes. You ask about competition law today. I think it's helpful to, and maybe essential, to start with competition law yesterday and the day before yesterday, when the drafters of what was the Treaty of Rome, the origin of the TFEU, were working in Brussels to produce a text which would establish the European Economic Community. They were encouraged by the United States to include something to do with antitrust, because that was seen as a vehicle for constraining gigantic power and hindering the dangers which led to the Second World War. So when the drafters were working, they didn't really have a clear notion of what it was that they were trying to enjoin. One of the drafters felt that religious discrimination should be targeted by the competition rules. And the drafts, which you can consult in the archives of the Council, it's rather fun, the drafts show that many slightly strange notions were advanced by the 6 countries who were drafting what is now 101 and 102 of the treaty. Now, for about 40 years, competition law was reserved to the public enforcement by the priesthood, the experts in Brussels. The Commission had the monopoly of granting approval of any text which was which involved restrictions of competition, and that could not be done by national courts, could not be done by national competition authorities. So competition law was a quite arcane specialty, and the enforcers, predominantly the enforcers in Brussels and a bit enforcers in France, in Germany and the UK, were nowhere near the status and importance economically, politically, even culturally that they have today. In the late 90s, it became obvious that the Commission's monopoly over the granting of exemptions to infringements or deals which were caught by 8501, the Commission's monopoly had to go, because the Commission had a theory which was that many, I won't say everything, but many deals were caught by the prohibition, needed an exemption, and yet in some years the Commission, working hard, could only deliver 8 or 9, 10 exemption decisions. So something had to change. And there was a massive change at the moment of the accession of 10 new member states in 2004. And from that time, we can see more economic considerations, more economic reality, and entering the targets of the European Commission. In the past, it had been confined to, shall I say, rather soft targets like export bans, which maybe were never enforced, but were technically not revoked. Technically, they were enforceable. So the Commission agreed that it could no longer hold the monopoly on the granting of exemptions, and it favored that competition law should be, my word is, nationalized. And since then, instead of being the preserve of the specialist authority in Brussels, the European Commission, and one or two national authorities, competition law has been thoroughly absorbed into the juridical framework of the member states, small and large. Now, that's a huge difference. That means that whereas in the past, a small number of decisions were taken mainly by experts and possibly not on matters of the first importance economically, after 2004, member state authorities and member state courts, as a routine matter, examined competition law questions. Now, where you might say 20 years on, and you ask, is the situation today a continuation of what I've described, or is it something with a new order of magnitude? And I would answer to that question, yes, both. That's to say, in the same way as the European Union has evolved over 65, 70 years, and in the same way as its powers, its responsibilities, its importance internationally have grown, so the challenges which demand attention by competition law have changed and grown. So we're now in a world, I would say, where competition law isn't, at least as practiced in Brussels by the European Commission, it isn't so much about punishing past infringements. It is more about how to regulate extremely technical, sophisticated markets where the law is now, with the DMA, Digital Markets Act, where the law is now no longer structured to involve an accusation, a complaint, an investigation, a reaching of a conclusion, and the determination of an infringement and the probable imposition of a huge fine. It's more related to how companies structure their business and the extent to which they grant opportunities to other companies who live in their ecosystem. Now, that means that the obligations being imposed upon leading technology companies are far deeper and richer and perhaps more controversial than in the previous regime. So, to answer less wordily your question, competition law evolves. Competition law has evolved gigantically in the 60, whatever it is, years since the adoption of Regulation 17 of 1962. and the targets are now so important and so heavy in terms of their economic significance that the approach to their pro-competitive or anti-competitive conduct has changed considerably.
And this leads us perfectly to a question which has two dimensions or two avenues. The role of discretion. The role of discretion from the perspective of enforcers, primarily public enforcers of competition law, and the role of discretion from the perspective of judicial authorities. When we talk about the former, if we look at competition law from the past, the period of legal formalism, economic formalism, simplifying things, there was a belief, at least in the minds of the stakeholders, that there is a singular economic truth discoverable if you work hard enough. Now it looks that there is more than one version of this economic truth, and it's much more adversarial, and given that other goals are being legitimized within the framework of competition law, it makes it even less axiomatic, even less syllogistic, even more unpredictable, so to say. And thus only political discretion, it probably becomes, it starts playing higher role from the perspective of public enforcers. But you have also this rich experience as a judge. So I'm very tempted to combine these questions, but let us now pause here with public enforcers, the role of discretion in public enforcers, and then revert to the judges.
Yeah, I think that in reality, the judge's discretion and the administrative exercise of authority are really phenomena which are, or concepts which are very, very close together. So there are a number of cases which go back a fair way, where the court, for example, Mr. Reuter, he sold his business and then he wanted to go back into his business, but he'd given a non-compete clause. And the non-compete clause was, I think, for maybe it was 4 years. And he wanted to go back into the business that he'd sold, that's to say, into the area of commerce where he'd sold his own business earlier than the clause provided. And he made a complaint. And the European Commission, I don't recollect the exact number of months, but he was, let's say, prohibited for 36 months from re-entering the sector. And the Commission thought that was too long, and they could have gone for maybe a shorter period, like 24 months or 18 months. And that seems to me, and a decision was taken that he could re-enter the marketplace more slowly than he had hoped, but more rapidly than the contract provided. And that seems to me a good example of an area where, as in administrative law nationally, the authority is entitled to reach its own conclusions and to enjoy a degree of respect and deference with respect to those conclusions, so, or determinations. So the child who is disabled is the child entitled to a free bus pass. Does the disability reach the level which justifies that concession? Now, the authority is the one who is in charge, and the authority should be trusted to do a proper job looking at that question. There are many administrative law matters where, as long as the inquiry has been fairly done, and as long as there is no corruption, and as long as all the evidence has been put for and against, then the authority should be trusted to get on with its own conclusions. In the Microsoft case, and I confess I was on the losing side there, in the Microsoft case, there's a very interesting paragraph which I think may no longer be the law, but it attracted attention 15 years ago when it appeared in the Microsoft judgment. And there, the court said, the general court said, the commission is entitled to deference when it comes to complex technical and economic matters. In other words, it may seem surprising that adding new features to an operating system without increasing the cost, you might say free of charge, that could be characterized as bundling, which is bad, or it could be characterized as offering a more richly featured product for the same price as the previous product, as the unimproved product. So the court accepted. Rumors are that this was not an easy decision. I can't speak to that. The court stated that when the institution exercises its determination with respect to complex technical and economic matters, then it's entitled to deference from the courts. And that brings me to the second half of your question. What about deference and discretion viewed from the point of view of the judge? The Luxembourg courts practice administrative law. That's to say, the general court is overwhelmingly involved in examining the actions, the administrative actions of the public authority, and deciding whether those were validly executed. Was the action in accordance with the applicable regulation or directive? Were the facts properly established? And so on. The decision of the Commission will always involve a degree of exercising discretion. And sorry about the motorbike. There we are. It's passed. Now, Mr. Leitenberger, formerly Director General in DG Competition, now a judge from Germany in the General Court, he observes that the Commission does exercise and should be entitled to exercise a normative choice. That's to say, how long is it appropriate and sensible for a non-compete clause to run? In a number of ways, the court in the 2000s granted more deference than I think was appropriate to the actions of the public authority. And with the case of Menarini in Strasbourg and the case of Halcor in Luxembourg, the two courts said in parallel, not the same wording, that as a matter of due process, factual determinations couldn't be decided in the expectation that judges would never interfere. To the contrary, says the court, the Human Rights Court in Menarini, it is necessary, it is required that there be a review in principle complete of the facts and the law before the taking of a decision. That's a matter of due process. Now, there will come a moment when the institution will be arguing, I am entitled, I am the expert, I'm the public authority, I have decided to make a normative choice that hybrid vehicles and electric vehicles fall into the same category, into the same market. Now, that decision is will be based upon a pile of economic and legal analyses saying yes. And there will also be on the file a pile of opposing economic analyses saying no. Now, I think that the court is obliged, when it looks at these questions, to give respect to the capacity of the institution to make what Professor Judge Leitenberger calls a normative choice. So, step back, where are we with the DMA? There, competition law is no longer being used as a criminal law, quasi-criminal, where infringements are challenged and punished. Competition law is being used to shape how the marketplace works and to pursue, not necessarily to achieve, fair play, equality of opportunity, or the existence of opportunity for all players. And instead of a snapshot of past history, the aspiration is that the DMA will be a code of conduct where the individual companies volunteer proactively a great deal of information about how they're doing business and accept that they may be ordered to change their behavior. So discretion, flexibility, deference, those are factors which will for sure emerge in or be critical in future competition cases and in recent competition cases.
And if you look, pausing with this Judge Leitenberger point about normative discretion to pursue what? How much of the greater vision is if this normative discretion in the hands of kind of administrative clerk who thinks that the ambition to change the world is too megalomaniac, it's better to protect competition and to improve things incrementally. It's one story. And if this normative discretion refers to fairness and contestability, open textured concepts of the DMA, and I would claim as an enforcer that I have a mandate to tailor this quasi-competition rules, compliance with these quasi-competition rules in a much more strategic, long-term way, giving priority to one non-competential, non-compliance cases and somehow turning a blind eye to another one. How far should this administrative normative discretion go?
Well, that is, as they say, the $64 million question, or 64,000. That used to be a big number. I think there is a point when a decision or a case has been well argued, and all of these enterprises have skilled lawyers, economists, technical experts, and it's a pleasure. I've worked with small ones and big ones, and it's very, very interesting, very stimulating. So there is a question in my mind, which I have written about a long time ago, about, I guess it's, in a sense, it's due process. This is quasi-criminal law. Are the mechanisms by which competition law decisions in the European Commission, by which they're taken, is there the proper balance between the rights of the defense and the efficiency and effectiveness of enforcement? So if we look at the Indian competition law in the first years of this century, Indian competition law suffered because it was, my word, over-proceduralised. There were too many opportunities for companies to appeal different steps in the enforcement process. So appeal, appeal, appeal. And the consequence of that was that things just didn't get decided. On the other hand, there could be a risk that, and I think this is true, more true in the old cases, where the case team were absolutely confident they were right and didn't want to accept alternative views. And where the case team pushed and pushed and pushed and got a decision out which was really contradicted by the facts, or which was somewhat where the factual determinations just were wrong. Now, if you look at a typical decision today, in a big case, it may well be 400 pages long. It may have 700 paragraphs. So all the facts are presented, and the footnotes are very, very, very extensive. But the danger is that it's almost non-justiciable, because 400 pages, 500 pages, it's very difficult to see what were the big issues in the case. I remember I argued Magill on behalf of the European Commission, and I think the Magill decision was 15 pages long, something like that. The judgment of the Court of First Instance was also short, and the solution to the case, which was a different approach from the Court of Justice, that was likewise far, far shorter than the judgments we see today. So if you're teaching, and I'm not telling you anything new, if you give to a student a decision that's 500 pages long and a judgment which is 200 pages long, the student is going to go to sleep or go and do something else. It's very, very difficult to grasp the essence of the case. And one or two people, including myself, have suggested that it might be useful to interject or interpose an extra hearing in Brussels by something like an administrative law judge who would decide the facts in on a bunch of matters which are controversial. Now, there is an adverse consequence to that, and that's delay. And I don't have a clear, I don't have an answer to how to balance speed and fairness, but I think balancing those two interests is a crucial obligation of the European Union. We can see different styles of enforcement. The CAT in London, where I have the honour of sitting as an ordinary judge, an ordinary member, that institution has a huge reputation and accords long periods for oral argument, much longer than would be expected in Luxembourg. Is that something to be learned from? I think that it isn't. It wouldn't be wrong. It wouldn't be inappropriate to have a look at whether the procedures in Brussels, which have been consistently upheld by the courts of the European Union, could they be improved? Would it be quicker? And would those who have participated emerge feeling, well, I'm annoyed at the outcome, but they certainly listened to us. As Vice Chancellor McGarry said, he was a very nice man, and he used to have students who would visit, and he'd say to them afterwards, who is the most important person in court today? Who should I be thinking about? And his answer was the party who is going to lose. And I think that that was true years ago when Mr. McGarry said it, and it's still true today.
Before moving to more specific questions, and in particular the current reforms of Article 102, and maybe the history as well, which you not only witnessed but also shaped, I wanted to ask, to pause on this judiciary decision making and the mechanics of thinking, this kind of legal sociology, how judges think. Is it the case that, or I know these are two extremes and two stereotypes, but just position yourself between these two polarities. On one hand, we can imagine a judge who is engaged in the process of discovery, kind of reverse engineering, discovering something, the truth with capital T, wearing the blindfold, being completely dedicated to this administrative scrupulousness and neutrality par excellence, not caring about the implications, just trying to discover the right answer, to provide the right answer. On the other extreme, we see the judge, the Themis, who gently removes her blindfold, so to say, and tries to see to look at the implications and the kind of societal reasonableness of what of the impact of the judgments on different parties and maybe broader on society. These are two caricatures, I imagine. So probably the truth is either somewhere in between, or it can be presented very differently. Please explain.
Well, I can't explain, but I can observe that if one sits in England or Scotland or Northern Ireland, I haven't done the latter, the intellectual importance of oral argument, where the judge and counsel are really fighting to discuss what should be the correct outcome, all the parties share a nationality and a background of legal training. In Luxembourg, there are 27 countries, 24 official languages, one working language, which is French. And so the the approach of a judge from Lithuania and a judge from Portugal or a judge from Ireland, their professional traditions will be very different. But they're sitting as colleagues. They sit in chambers of 3 or 5 or 15, and they produce a verdict which each must sign. So the process of reaching a judgment is consensual. It is in Strasbourg possible for judges to make a dissent, but it's not common, but it does happen. In Luxembourg, for the moment, I suppose it might change, the judgments are the common opinion statement of the law of all the sitting members. Now that has an effect on the drafting of the judgment, and it can happen in unfortunate cases that both sides claim victory because the judgment has phrases which appear to go in opposite directions, but which can just maybe be reconciled. That's one thought. I think that it is said, not my opinion, it is said in the books about how courts work that judges commonly reach a conclusion, this is where I want to go, and then create a narrative, legal and factual, which justifies that conclusion. That's not a bad way to go, but it doesn't match the theory that the judge is merely the la bouche de la loi. That's to say, the neutral, blind stater of the law on the basis of the facts that have been put before the judge. The reality, I think, is that judges in a big competition case have to make a determination of whether the crucial facts were a valid basis for the determination, for the bottom line of the decision. That's a very kind of obvious statement, but it goes back a little bit to deference. This is administrative law. It isn't enough for the judge to say, I wouldn't have decided that way. There must be illegality, infringement, violation of norms before the judge will overturn matters. I think it's interesting to look at the judgments in competition cases from the Court of Justice and from the General Court. The difference is that before the Court of Justice, you can find briefer judgments, shorter judgments, which address the principles which are put to them by member state courts. So I think it was a Lithuanian case where the deal was in a shopping mall, the supermarket said, we'll come there, but we want to be the only supermarket. And a question was referred to Luxembourg. how should we address that from the point of view of competition law? There are quite a number of cases where I find, especially when teaching, the judgments from the Court of Justice much easier to analyze with students. By contrast, for the reasons that I've said, notably the extreme length of judgments and the more extreme length of decisions, it often happens, sadly, that the court is, sadly, understandably, the court examines questions of formality, access to the file, opportunity to comment, daily time limits, and the judgment may be on the big issue of principle ducked or postponed. That's less the case now, but there were cases in the past.
And I also wanted to connect it with the evolution or in enforcing, let's say, enforcement priorities of exclusionary abuses. Can you please provide to us your reading of the history of 102 based on exclusionary cases and through the prism of the current discussion and current revised guidance paper and draft guidelines?
This may be a bit heretical, but I think it's good that guidelines are drafted. The words of Article 102, I don't know how many they are, but it's less than 100 words, I guess. So maybe it's 200 words, but it's very short, and it's just long. It's just big questions of principle. Now, guidelines are useful in that they indicate enforcement priorities, but I have been in so many cases where I won't say the guidelines weren't followed, but the guidelines didn't really address the core question, which was in dispute. So personal view, I have always felt that too much weight was given to the wording of guidelines because they are not a really reliable predictor of outcomes when there is a controversy. So the detailed parsing, argument line by line, I'm not opposed to it. It's natural, but I don't think that reaching conclusions in the guidelines is a reliable predictor of whether a particular practice will or will not survive scrutiny. It's not that the public authority is casual, because of course they know that one thing which is objectionable or controversial, I should say, is the guidelines weren't respected, or the guidelines, this did fall or didn't fall within the guidelines. Yes, of course, that's important. But I think that they can't be a get out of jail free card in a particular circumstance. We can observe that in a couple of recent cases, I'm talking of merger cases, the court has said, yeah, it's true. This merger was not caught by the letter of the law, but we're not going to disagree with the European Commission, which said this is an important matter and we're going to look at it more closely, or we're going to challenge it, even though it does not fall within the criteria. Now, that sounds as if I'm saying the guidelines are unimportant. No, guidelines obviously are important. But I am saying every case is different, and the guidelines will be helpful in establishing the climate, the overall framework. But even though they have been very carefully drafted, I don't think they are a reliable predictor of whether, a definitive predictor of whether enforcement action will be taken or not.
In spring 2025, you have delivered a paper to a large audience of an event organized together by the University of Edinburgh, Glasgow, UCL, on the eve of the ICN meeting hosted in Scotland in few places. And one of the central messages, so the paper addressed the role of private enforcement. And we see here the topic becomes much more important these days than it was 10, 15 years ago. And obviously it depends whether we're talking about ex post competition law or DMA, where the obligations are much more interventionist and so the fruit is hanging very, very low, so to say, designed to speed up the process of public enforcement, supposedly, according to this narrative. Obviously, a lot depends whether it's standalone or follow-on action, whether it's third-party funded or not. So there are many variables, many parameters which obviously limit the straightforwardness of the answer. But if I may ask you to highlight the key messages of the paper and your position on this rapidly evolving area.
Oh, it was a very long time ago. I've forgotten. Though indeed, Edinburgh is a lovely place to have conferences, and the ICN was very, very impressive to see 105, 110 countries, competition experts gathering together to exchange ideas. Very, very, very interesting. Private enforcement. It's obviously a good thing, and it has never been seriously doubted that the victim of a competition law infringement ought to be able to get compensation. Back in the 1970s, a member of the Commission Legal Service, John Temple Lang, went round the 9 member states and produced a convincing article saying private enforcement in each member state is possible. Now, but in reality, there were very few private enforcement actions. There were some, but private people against the public authority, against the infringer, quite rare. So in the 1990s, there was a rapprochement between the United States and the European Union. Hitherto, public enforcement and indeed private enforcement in the United States was regarded as too interventionist, too aggressive, too extraterritorial, too imperialist. And so there were clashes, rare but big, between the institutions in Europe and the institutions in Washington. And in the 90s, Carl van Meert, the commissioner, did deals whereby, or it was a gradual process where comity, we respect you, you'll enforce in your territory, we'll enforce in our territory, and we'll stay close and share ideas. That eliminated previous rivalries between the United States and the European Union. Now, the challenge for private enforcement, there's a number. One is cost. If you're the mother of three children and they each get a West Ham football shirt, and the price of that shirt has been inflated by a seller's cartel among the football strip manufacturers, then you ought to be entitled to some compensation. But going to court is absolutely unrealistic for such a relatively small sum. So, on the one hand, we want to avoid American abuses. It's believed that treble damages convert the lawyer into a sort of privateer, where the lawyer is there as an entrepreneur acting for himself, as opposed to the lawyer rendering service to get justice for a client. And so there was a strong wish with respect to the generalizing of rights of enforcement to avoid so-called American excesses. The first test was the directive on dangerous products. And those were products which did not, physical products, which did not deliver the level of safety which the purchaser could reasonably expect, hope for. Now, that phenomenon, the adoption of that directive was very strongly opposed by the leaders of Europe's consumer industries. Nevertheless, the abuses which were feared have almost not at all materialized. Cases are relatively few, and the implementation of the directive into member state law has worked quite, I believe, quite smoothly. And I have been involved in litigations about contaminated blood, for example, whether that was a defective product, both rather important questions. So the example of empowering private citizens to sue on the basis of rather absolutist principles worked quite well for defective or dangerous products. Now then, with respect to competition law, as you know, there were cases like Courage and Crean, which went back and forth on the question of how to establish damage, standing, all kinds of stuff. But gradually, the notion was established that victims of competition infringement did have the right to go to court. The directive which followed is an implementation of the principle, I would say, of effectiveness. That's to say that if there is a right, there ought to be a remedy. Now, there is a danger. And the danger is that if too many people bring competition claims which are hypothetical and difficult to grasp, that's going to take a great deal of judicial time. There was a case last year in England and Wales involving water and sewerage services, and there the person who wanted to lead the class and who sought to have her class certified said that she wished to represent the millions of households who had been overcharged by water companies, whose payment by households was linked necessarily to the degree of truthfulness by which they reported spillages or successful execution of their statutory jobs. Now, it was decided in that case that the underlying legislation didn't leave any jurisdiction for the competition court. Nevertheless, there are quite a number, I think it's nearly 20 class cases where the class has been certified. Now, that means that an enormous amount of judicial time will go into verifying the validity of the claim, and then a considerable amount of effort will go into the distribution of damages, if any are awarded. And I haven't yet mentioned a very important element, and that is litigation funding. When I started practice, it was professional misconduct for a third party to fund litigation and to have an arrangement whereby the funder would get a substantial payback. But that has now changed, and that has revolutionized private enforcement in a number of countries. That's to say, the class representative, whatever they're called in different countries, he or she may have received a promise of £30 million in order to bring the litigation. Now, you can argue as to whether that is an incentive to bring litigation which is not obviously well-founded and which is going to clog the courts, or you can say it's important that consumers of high-tech equipment who would like to have easier access on their platform, to certain competitors, you may say that it's important for them to have that enhanced chance. I'm just observing that the future of private enforcement has been vastly transformed by the realization that empowering consumers isn't a bad thing, by the damages directive, by the availability of speculative litigation funding. And I don't know where the process is going to end. One interesting question is the extent to which competition litigation is consuming judicial resources which might otherwise be devoted to other matters, civil and criminal, which are of great importance to society. We are in a process of evolution, and I don't know where we're going to end up.
Before inviting you to provide recommendations to students, I wanted to ask you two more questions, Ian. The first one, is about different jurisdictions which adopted recently or not that recently competition law. You communicate with many stakeholders, you see and sense and witness and observe different experiences, different successes and failures in different countries in terms of how they adopt, how naturally, organically they develop and implement. The time where of this kind of EU US exceptionalism is gone, and we can learn, and we are not shy to learn from other jurisdictions. Do you see some examples where we can say, wow, that's really impressive, or they are doing the great job, and maybe they are just on the right track, so to say, or it's everything jurisdiction specific, and it's very hard to transpose the experience of one country to another, particularly to such mature jurisdiction as EU, UK, or US?
I'm not going to give anyone a bad mark. I have been involved in competition controversies in quite a number of countries, and I have visited universities and competition authorities in a number of countries. So I can see a great deal of professional skill in, well, one recent one where I had the pleasure of visiting and participating in a session was Lithuania. And there, the sophistication and the robustness of the competition bar and the confidence of the bar and the confidence of the judges, that was really impressive. It's true that there are, at national level, very big differences in how courts are funded, how they operate. If you go to the Competition Appeals Tribunal in Salisbury Square, that's very, very well prepared, excellent advocates, and judgments which are a good balance between principle and detail. They're not too long, but they get to the essence of things. I attended in Portugal 2 weeks ago a meeting of the Association of European Competition Law Judges, and there were 120 present. And Professor Richard Whish gave a talk, as well as national experts on different jurisdictions who spoke. And we had a day on, you might say, general principles, and then the second day was devoted to experiences from each of the different states. So the differences in procedure and what you would see if you sat at the back of the court or if you went to the hearing before the Competition Authority, there are big differences there. There just are very big differences. That doesn't mean that one is better than the other. You could argue that this one is preferable, or I'm more comfortable with that one, or you could say lack of funding is clearly a problem in that country. But no one can doubt that competition law has been, using my word, nationalized effectively. The availability of competition law arguments is now routinely taught to new students, and even those with grey hair are, I think, aware that competition law has to be taken into account. So I would say that if you listened to the judges at the meeting in Portugal, you would see people who really do share a common discipline. If you went to where they are, as it were, doing business, where they're sitting, where their authority resides, or where their court is situated, you'd see big differences. But those would be more in terms of resources and procedures, and maybe to a degree a level of confidence or not.
Yeah, and I keep exploiting your skill of being, among other things, also a generous judge, jumping from one topic to another and immediately delving deep into. So next question is also different, namely maybe your recommendation to academics, because in among other your incarnations, you are also an academic, UK academic, long-standing. The amount of information is an avalanche. We producing papers, participating in events, and also dedicate a lot of time to students, etc. How do you reflect upon the current situation, and maybe what would be your advice to mid-career academics in the UK and beyond?
Oh, now that is not a question I expected. Well, there's a lot of competition between academics, and that's a good thing. Access to publications is easy, or blogs are easy. If you want to write about a case, you can do so, and you'll find that a few eyeballs will rest upon it. I think simplicity and accessibility, digestibility, is extremely important in academic writing, and it isn't always present. I believe that too often academic articles about a new case assume the validity of what appears in the decision in terms of factual history. I think that it is by looking at individual cases and looking at the arguments on both sides, ideally by getting input from both sides, that a good academic article or a better academic article can appear. I would also say that legal practice is a wonderful way of learning the law. Academic articles often underestimate the difficulty of bringing the case. At the moment, we may note in the United States that although some of the actions of, or a number of the actions of the US government would appear to be at the outer edge of what's acceptable, the procedural difficulty which those who wish to challenge the measure has often been the reason why the merits of the measure were not examined by US judges. So in Europe, I think that it's good to read carefully the factual basis for the authorities' determination, but I would like to insist on people checking out the facts not skeptically. That would be my recommendation. And also look at the old cases. Look at the cases of Mr. Bullock, who had the battle with Johnny Walker. Look at individual opportunities which competition law has permitted to be advanced.
And from your recommendation to academics to your recommendation to students.
Students, understand the political dimension as well as the technical competition law dimension. Study history. Don't expect the law to develop as clearly as real estate law. When you buy a building, when you bequeath a building, when you own a building and complain that your neighbor has encroached on your land, there is an immense amount of authority, and you can have stainless steel precision. The law is usually very, very clear. But of course, there can be litigations. Competition law has the uniquely, I think, questions of fairness, morality, economic reality. It's a very plastic field of inquiry. And that makes it fun.
Ian Forrester, thank you very much for sharing your bright ideas with all of us.
It's a pleasure. I look forward to visiting Exeter one of these days.
We will be honored to host you.